Using a fake ID to get into a bar is as common for college students as sleeping through Friday morning classes. In the District of Columbia, though, like most places, using a fake ID is a crime. This video will answer several important questions about fake ID and alcohol law in the district. Can you get arrested for using a fake ID? If arrested, what to expect in court? And finally, should you hire a criminal defense lawyer if you are arrested? My name is Joseph Scrofano, and I'm the founder of Scrofano Law PC, where we represent individuals under investigation or charged with a crime in the District of Columbia, Northern Virginia, and the Maryland Capital Region. First, can you get arrested for using a fake ID in the District of Columbia? The answer is absolutely yes. There is a criminal charge in DC for using a fake ID. This charge is referred to as misrepresentation of age or an ABC violation. If caught with a fake ID by law enforcement in DC, you will be arrested, booked for this crime. You will be prosecuted by the Office of Attorney General for the District of Columbia. Fortunately, they do not prosecute these crimes as aggressively as they do DUI type offenses. And what will be the subject of a future video, a DUI arrest for an underage drinking case is treated much more aggressively than a fake ID offense. Over the years, we've tended to see the most common places where these fake ID stings take place are in Georgetown, and the maximum penalty for misrepresentation of age increases in severity for repeat offenders. For the first conviction, a maximum penalty could be 90 days in jail and/or a $500 fine. A second conviction carries a maximum penalty of 180 days in jail and/or a $1,000 fine. Any conviction for this offense carries a driver's license suspension for a period of 90 days to 1 year as well. There is also a different type of charge for contributing to the delinquency of a minor, which carries a maximum penalty of 180 days in jail and/or a $1,000 fine for a first offense. For second and subsequent offenses, the maximum penalties do increase as well. Now, the most common scenario we see for contributing to the delinquency of a minor is a college student who is maybe 21 or 22 buying beer or liquor with an underage friend who is present that might be 19 or 20 and then getting caught up in some type of sting. Now, while these maximum penalties I mentioned for each offense sound big and scary, it's very unlikely that anyone who's arrested for misrepresentation of age or contributing to the delinquency of a minor will be sent to jail. And that's because the law has built-in diversion programs. Now, this brings us to our second question. What to expect in a court case if you're arrested for a fake ID? After being arrested for a fake ID, you'll likely be released from the police station after a few hours with a citation to return to court on a specific date. If you fail to appear on that date, the court can issue a warrant for your arrest. For a first offense, the law provides for a diversion program where, if successfully completed, can result in the person arrested getting their case dismissed and their record expunged. For information on what diversion is, be sure to check out our video, What is Diversion? So for fake ID cases, the diversion program usually involves paying a $200 fine and completing 2 days community service, and in exchange, the prosecutor will dismiss the charge. Once dismissed, you'll have to wait 6 months to have your record expunged, and once the 6 months elapses, a lawyer can file a motion on your behalf to have your arrest sealed and removed from your record. Now, you can expect this process to take a few months, but in the end, you will get out of the situation without having a conviction, without having arrest, and without having a criminal record. Now, do you need a lawyer for a fake ID case? The diversion program and 6-month expungement are codified in the DC code, which means any first offender is entitled to diversion whether you have a lawyer or not. Now, if you get caught using a fake ID a second time, all bets are off. In that case, you will be prosecuted like any other misdemeanor and would have to either plead guilty or take your case to trial. In addition, diversion applies where someone uses a real ID that belongs to an older person who looks like them, like an older sibling. Where the ID is actually forged from some type of computer program or someone is selling fake IDs, there could be serious implications under federal law where the DC diversion program would obviously not apply. In any event, I always recommend obtaining a lawyer when you have a criminal charge, even if it's a first offense fake ID case. Most college students don't have income, and so you'd likely qualify for a court-appointed lawyer. So the real question is not, do you need a lawyer? You do. But the question is, should you hire one or take the court-appointed lawyer? Now, if you can afford it or your parents are willing to pay, I'd recommend hiring a lawyer for two main reasons. First, in these types of cases, the court does not actually appoint a lawyer directly to represent the individual. Rather, there's a stand-in court-appointed lawyer who will walk the person through the agreement, appear in court on the arrested person's behalf on their arraignment court date, and that stand-in will typically be there on the return date to get the case dismissed if the arrested person completes the requirements, though it may be a different stand-in lawyer in the second court date. That lawyer will not ultimately file the expungement motion, and you definitely want to get the arrest taken off your record. Another advantage of hiring a lawyer in advance of your court date for a fake ID case is you may be able to get your case dealt with faster. Normally, you need to go to court twice. Once to get arraigned and enter the agreement, then a second time, maybe a few weeks or a month later, to get it dismissed. However, if you hire a lawyer in advance, that lawyer may be able to contact the prosecutor in advance of your first court date and arrange for you to complete the community service and pay the fines prior to the first court date. In that situation, you could actually show up to your first court date and immediately get your case dismissed without having to come back for a second date. That would start the clock on the 6-month waiting period to get your arrest expunged sooner and save you the time and hassle from having to trek down to court for a second time to get the case dismissed after you complete the requirements. The last thing to think about is that police often notify the arrestee's university, and the university could very well take separate disciplinary action. Now, while the law is set up that this arrest does not destroy your life or your future, any arrest is a serious matter, and having a university disciplinary case can be notoriously difficult. If you or a friend or loved one, looking at you parents with college-age students, get caught up in a fake ID or contributing to the delinquency of a minor arrest, contact us today for a free consultation. And don't forget to like this video and subscribe to our channel if you're interested in learning more about all things criminal and constitutional law.